Welcome to The Explainer. We all kind of have this built-in sense of what's fair, right? But what happens when the very system that's supposed to deliver justice, the law itself, actually gets it wrong? Well, today we're diving into a really fascinating bit of legal history that answers that exact question. I mean, it sounds like a total contradiction, doesn't it? Laws are supposed to be about justice. But what if following the rules word for word actually leads to a result that is just fundamentally unfair? And this isn't just some philosophical question. It's the real-world problem that sparked a revolution in the legal world. Let's get into it. So to really get a handle on the solution, we first need to understand the problem. And for that, we've got to go way back to the early days of English common law. Now look, having predictable rules is usually a good thing, right? It gives us a sense of certainty, you know what to expect. The problem with the early common law, though, was that it was just so rigid. Imagine a law that says you have to repay a debt on a specific day, period. What if you were robbed on your way to pay it? The common law just didn't have the wiggle room to deal with the messy, unpredictable stuff of real life. This right here gets to the absolute heart of the issue. On one side, you've got the common law, and it's all about sticking to the rules for the sake of certainty. But on the other side, you have the huge problem that created, a system so inflexible that it often produced outcomes that just felt plain wrong. There was just no mechanism for case-by-case justice. If your story didn't fit perfectly into one of their little legal boxes, well, you were pretty much out of luck. So you've got all these people facing unfair legal decisions, and eventually something had to give. The system had to adapt. And what it did was create a kind of parallel track, a whole new system designed not just to follow rules, but to actually achieve fairness. And this new court was called the Court of Chancery. What made it so different was that it wasn't tied to the same strict rules as the common law courts. It could actually look at the specific human details of a case and step in to make things right, offering solutions where the common law just threw up its hands. You know, the name of this system really tells you everything you need to know: equity. It comes from the Latin word aequitas, which is what the Romans used to talk about things like justice and fairness. So equity, from the very beginning, was all about one thing: getting to a fair result. And what I love about this quote is how perfectly it nails the mission. See, equity isn't about just tossing out all the rules. No, it's all about creating a balance. It's the secret sauce that lets a legal system have both predictable rules and the flexibility it needs to be fair in unique individual situations. So this new way of thinking, this focus on fairness, it didn't just fix old problems. It actually led to the creation of one of the most powerful and honestly most important legal tools that we still use today. Think about it. The Court of Chancery needed a way to manage these really complex situations that the old system couldn't touch. And that necessity, well, it sparked an absolutely incredible innovation. And that tool was the trust. People often call it the single most important creation to come out of equity. It was born directly from this new flexible way of thinking about justice. So what exactly is it, and how does this thing even work? Okay, so at its core, it's a remarkably simple but brilliant idea. A trust is basically a special kind of ownership. It splits the legal control of something, like property or money, from the person who actually gets to enjoy it. So you have one person managing the asset, but they're doing it for someone else's benefit. To really wrap your head around it, we just need to look at the people involved. Every single trust has three key players that make the whole thing go. First up, you have the settler. That's the person who starts the whole thing. They create the trust and put the property in. Next, you have the trustee. This is the person who legally holds and manages that property. And they have a super strict duty to follow the settler's instructions. And finally, there's the beneficiary. This is the person who the trust was made for in the first place. They're the one who gets the benefit from it all. This simple little triangle allows for some incredibly flexible and secure ways to manage property. Now, I know this might all sound like some dusty old legal history, but believe me, the trust is anything but a relic. It is a massive part of our modern world. Yeah, seriously. This is not some concept you'll only find in a textbook. The trust is a living, breathing idea that supports huge parts of our society, from your personal finances all the way up to global business. Just think about the world around you for a second. Trusts are used all the time for family and inheritance planning, to make sure assets are taken care of for the next generation. They are the absolute backbone of countless charities, funding everything from hospitals to universities. Big corporations use them to manage assets,
And you can even set them up to protect things like forests and national parks. It is an unbelievably versatile tool.
So we've seen how this basic human need for fairness created a whole new legal system and this incredibly powerful tool, the trust. Today, the lines between the old common law and equity are a lot blurrier, but it leaves us with a really important question to chew on. Even if we have better rules now, is real justice even possible without a system that is actively, consciously designed to look for what's fair on a human, case-by-case level? It's definitely something to think about.